5 seconds to go. Start. Children below the age of 18 years was subjected to any sexual assault is a serious crime, and by not reporting they are screening the offenders from legal punishment and hence be held liable under the ordinary criminal law and prompt action be taken against them in accordance with law. In Vijay Madanlal Chaudhary's case, Supra, this court observed that the length of punishment is not only the indicator of the gravity of offence, and it is to be judged by a totality of factors, especially keeping in mind the background in which the offence came to be recognized by the legislature in the specific international context. In this context, it is also relevant to note that the United Nations Convention on Rights of Children, which was ratified by India on 11 December 1992, requires the state parties to undertake all appropriate national, bilateral, and multilateral measures to prevent the inducement or coercion of child to engage in any unlawful sexual activity, the exploitative use of children in prostitution or other unlawful sexual practices, etc. Articles 32 and 34 of the Convention have placed a specific duty on the state to protect the child from all forms of sexual exploitation and abuse. Prompt and proper reporting of the commission of offence under the POCSO Act is of utmost importance, and we have no hesitation to state that its failure on coming to know about the commission of any offence thereunder would defeat the very purpose and object of the Act. We say so taking into account the various provisions thereunder. Medical examination of the victim, as also the accused, would give many important clues in a case that falls under the POCSO Act. Section 27(1) of the POCSO Act provides that medical examination of a child in respect of whom any offence has been committed under the said Act shall, notwithstanding that a first information report or complaint has not been registered for the offence under the Act, be conducted in accordance with Section 164A of the CRPC, which provides the procedures for medical examination of the victim of rape. In this contextual situation, it is also relevant to refer to Section 53A of CRPC that mandates for examination of a person accused of rape by a medical practitioner. It is also a fact that clothes of the parties would also offer very reliable evidence in cases of rape. We refer to the aforesaid provisions only to stress upon the fact that a prompt reporting of the commission of an offence under POCSO Act would enable immediate examination of the victim concerned, and at the same time, if it was committed by an unknown person, it would also enable the investigating agency to commence investigation without wasting time and ultimately to secure the arrest and medical examination of the culprit. There can be no two views that in relation to sexual offences, medical evidence has much corroborative value. Bearing in mind the position with respect to the exercise of power under Section 482 CRPC, the provisions penal and procedural under POCSO Act, we will proceed to consider the case on hand. The FIR registered in the case on hand would reveal that it came to be registered on coming to know about the suspected commission of sexual offence against minor tribal girls against unidentified persons. Failure to report regarding the commission of the offence under the POCSO Act, despite knowledge about the same, is the accusation against the respondent revealed from the charge sheet. The FIR reveals the ingredients of an offence under the POCSO Act, and the real magnitude of the same was revealed during the investigation as stated above. On completion of the investigation, based on the materials collected, the officer in charge of the police station concerned formed an opinion that a cognizable offence as mentioned therein appears to had been committed, and that the persons named therein, including the respondent herein, appears to have committed the offences specified against them, and filed final report under section 173(2) for prosecuting them. It is the stated FIR dated 12th April 2019 and the stated charge sheet dated 8th June 2019 which were sought to be quashed and consequently quashed as per the impugned judgment. If FIR and the materials collected disclose a cognizable offence and the final report filed under section 173(2) CRPC on completion of investigation based on it would reveal that the ingredients to constitute an offence under the POCSO Act and a prima facie case against the persons named therein as accused, the truthfulness, sufficiency, or admissibility of the evidence are not matters falling within the purview of exercise of power under section 482 CRPC, and undoubtedly they are matters to be done by the trial court at the time of trial. This position is evident from the decisions referred supra. Sto.